Thank you everyone for joining me today and the fantastic CEDAW's People's Tribunal. My name is Nasreen Shah. I'm a barrister at Great James Street Chambers, and I specialize in crime, family, and extradition. I'm also the founder and the director of Her Bar, an online hub designed to support and promote women at the bar with the view of achieving greater equality. Now, just to give you a bit of a brief background, before joining the bar, I used to work at the European Court of Human Rights as a judicial assistant, where I had the privilege of working for Judge Turkovic of Croatia, a staunch champion of women's rights. And I also have an extensive background in charity work, in particular working frontline in the women's sector here in the UK. So a lot of the views I'm going to express today are from my practice as a barrister and from my work frontline here in the UK. Working within the legal department of a grassroots charity here in London, LBWP, a domestic violence charity in particular, where we supported specifically women from minority ethnic backgrounds, I had the privilege of partnering with a number of organizations, well-established national organizations, and the grassroots frontline organizations that help women flee domestic violence on a daily basis. Our work focused heavily on the obstacles women encountered, such as no recourse to public funds, the impact of which was in particular quite grave on women survivors of domestic violence. Women were unable to seek appropriate housing, having largely been left to survive in unfit temporary government accommodation that even resulted on occasion in the development of chronic medical conditions. They were unable to support their children, and if it weren't for the charities and the food banks, we would find that a lot of them would be without shelter and food. At LBWP, we used to work closely with our refugees in organizations such as the Magpie Project and the Unity Project, the latter who actually challenged the validity of no recourse to public funds. In 2020, we finally got a judgment in the case of Anor in 2020, where the High Court actually declared that part of the no recourse policies breached human rights. The policy was unlawful, and the government had to make changes. Another key change in terms of women's rights has been the Domestic Violence Act of 2021. LBWP, amongst many other third parties, made recommendations to the Joint Committee as to the needed protections in law for women. I had the privilege of making particular representations about the inclusion and recognition of migrant women within the Act. Intersectionality being a key concept that the government still appears to struggle with today. Now, the Domestic Violence Act, as it stands, is certainly progress, but it does not go far enough. Whilst there has been some improvement from the legislative perspective, women are still not adequately protected under the current framework. The proposals in the President's report of the CEDAW People's Tribunal make these bold suggestions to incorporate CEDAW effectively into a fragmented, uneven legislative framework within which we're operating currently. We need to give consideration as well far beyond that, to the education of women and girls on the subject of domestic violence. Recognizing what it means, what it is, and knowing where to turn for help when it is needed. This is a key area that in my past work we found was much needed and underrepresented. What is often disregarded by society is the larger cultural differences and how women are not adequately supported or understood by generic services. There is more than one type of woman, and not everyone can be assisted by going through the motions, and certainly not be assisted by being treated like a tick box exercise. That being said, it leads me to the practicalities of navigating the justice system as a woman. For instance, in crime, statistically, women are still the primary subject of harassment, abuse, and sexual violence. Now, there's different strands as to how the criminal justice system operates. For instance, we have the CPS, the Crown Prosecution Service. Since domestic violence has become part of their internal strategy and policy framework, there has been an uptake in prosecutions in that area, certainly in the magistrates' court. To give you a real life example, when I started prosecuting as a pupil, within 3 to 4 months, I had already prosecuted 84 domestic violence trials. Now multiply this with all of the barristers, juniors that are out there who prosecute in the magistrates' court. Now, that being said, the picture in the Crown Court is still very different. The most serious and heinous offenses against women, unfortunately, are still underrepresented in the criminal justice system. Prosecutions are brought scarcely. And we have the statistics to show this. For example, where there are around 58,000 reports of rape a year, only 2,100 are being prosecuted. Now, this might sound very shocking to a lot of you, but it is a stark reality. This is attributable to many factors, many of which have received a lot of attention in the news, but a prevalent one, and one that is being considered a lot these days, is underfunding. Underfunding at the investigatory stage. For instance, is the public really aware that one detective is responsible for at least 10 to 17 rape cases from the outset until they hand over all of their evidence for charging? Also, barristers have left the profession due to the lack of support and acknowledgement by the government. Well, we now have what we call a CLAR report, but the question is really, does it go far enough? What it does mean, in real terms, is that we lack competent representatives across the entire justice system who can adequately defend as well as prosecute these cases. And this has a reverberating impact on women across the country who want to see justice done. The implementation of proper legislative safeguards and government support is not only pivotal, but the only way forward to truly ensure equality and protection for women under the law. Now, a positive feature, most recently, has been the Stalking Protection Act of 2019. This particular piece of legislation enables the Metropolitan Police to seek injunctions on behalf of victims before any, or if any, criminal charges are being filed. Arguably, from my experience, stalking protection orders are in some ways a step up from a non-molestation order issued in the family court. Perpetrators have known to work within the confines of the restrictions of a non-molestation order to still abuse their victims. An example I could give you is a restriction not to go near a victim's property. If it is said they ought not to be within 100 meters, means if they are within the property in 150 meters, they're not in breach. And the police is restricted. They cannot intervene. Such issues remain a common factor in family court cases and are often addressed in what we call fact-finding hearings. This actually leads me into the notion of family law. This is an area where arguably the most changes have ensued recently. Now, proper training for the judiciary and, mind you, the advocates should still be pursued. Courts ought to be properly equipped in dealing with the reverberations of trauma. Every survivor is different. There is no rule book on how to deal with or work through the abuse perpetrated, and allowances need to be made for that. No individual is the same. And judges and advocates still, to this day, struggle at times to make that very recognition. Now, family courts are adversarial in nature. And in spite of the harm report in 2020 and the implementation of the Domestic Violence Act in 2021, there are still elements within the family courts that put women at risk of harm. For instance, the courts still favor contact with both parents, even if one of them has been found on the balance of probabilities, meaning more likely than not, to have perpetrated abuse against the other. This in itself keeps survivors from healing. At the start of the COVID-19 pandemic, for instance, I was still working at LBWP, and we saw an incredible spike in the demand for support. And that also includes support in family court. This at one time resulted in my actually being responsible for 175 women with their 246 children. Now you need to bear in mind, this is one small grassroots organization. Now think about the effect COVID would have had across the country and the level of trauma that was inflicted and the socioeconomic challenges that women faced and still face today. As professionals, we can always acknowledge the benefits of having both parents in the children's lives, both parents to take care of them. But the real question is, at what cost? At what cost do we want to keep a family intact? That being said, there's been some, and if I may put that in quotation marks, acknowledgement of the levels of abuse inflicted upon largely women in this case. There have been some key developments, such as the case of R.H.N., which addressed coercive control and the limiting nature of Scott schedules, where we set out the incidents of abuse that we allege in family court. It has now allowed advocates to go beyond what a schedule dictates. It's allowed for us to address the underlying issue of coercive control, because largely when abuse is inflicted, it's not just one incident, it's a pattern of behavior used to undermine another individual. And even the other day, we've now had for the first time the High Court acknowledging and using the term gaslighting in a case. I make it very clear, this is only a first step, and arguably an overarching implementation of CEDAW into domestic law would be more effective than an amalgamation of individual legislative changes. CEDAW in itself is the most dynamic and the most contested human rights instrument there is. Its purpose is to advance women's rights globally. That being borne in mind, we need to advance women's rights together here in the United Kingdom. It is the reaffirmation of faith in fundamental human rights, the dignity and worth of every human person. And it is the one instrument making clear that rights ought to be equal between men and women. So I think in closing, I'd just like to say, there is a lot of work still to be done across the entire justice system. And that is the very reason why we need to fully integrate CEDAW into domestic legislation. I'm very grateful to all of you for listening to me today. And if you do want to follow my work or the work of Herbar, please do follow us on Twitter at Herbar Limited, or visit us on Instagram, and do reach out if we can be of any assistance to you at any time. Thank you.